We've been talking to Will Davis, who's the founder of the Campaign for Shared Parenting, hearing from him about his views. Will, you've started the UK Campaign for Shared Parenting. Tell us a little bit about what you're intending.
Well, what I intend quite simply is a change in the law. At the moment, the law is very vague, certainly the statute law. The Children and Families Act 2014 is very vague in what children should have when two parents separate or divorce. It says that it's the best interest of the child for there to be some involvement. Sadly, there was a third reading of the bill, and there was an interjection by Baroness Butler-Schloss, who said that involvement can be defined as direct or indirect, but not any particular division of a child's time. This means that countless children are being let down. Countless children are being denied their right, and it's about their rights, not the parents' rights, their right to have a relationship with both of their parents on a more or less equal footing, with a more or less equal division of time, assuming there's no safeguarding issues. What we want is the law to change. The law is behind other countries. Sweden is the one which is always mentioned. They had a rebuttable presumption of shared care in statute and case law since 1998. But there's other 2006, Belgium, 2009, the Netherlands. More recently, Kentucky in the States and several states over in the US are changing to that. What we want is something like House Bill 528 in Kentucky, which basically says that the law presumes that unless it can be shown that it is not in the child's best interest, and that can cover a whole range of things, practicalities, where it's not in their best interests, or abusive parent, etc., etc. But where it cannot be proved that it is not in the child's best interest, then the de facto starting position, or de jure would be starting position, is that the care between both parents is divided as equally as practically possible.
And
so it's a little bit like a shift.
What's the objection to that? Why do you think anybody objects to that as a reasonable starting point for a family case? What kind of objections are you coming across?
It's difficult to see what objections there are to that. And it's very hard to formulate an objection. Now, obviously, we hear the sort of the old chestnut arguments like, well, that's, as Baroness Butler-Schloss herself went on record saying, children need to have one stable home. It's a lot of toing and froing between parents. What about if there's abuse? What about if there's alcoholism? Well, let's deal with those issues. Now, firstly, if you have a situation where it can be shown that it's not in the child's best interests to have a division of care, an equal division of care, whatever that reason is, if one of the parents is abusive or they're living too far away, whatever it is, then that's fine. What we are not doing is saying, let's get a calculator out, let's get a spreadsheet out. It has to be 50-50, no questions asked in every single case. That is exactly what the campaign is not about. So that's one argument. The other argument is a scientific one. Sadly, the studies which seem to have more influence are the studies which go against the consensus. Right. Studies like the Macintosh study in Australia, studies like the Emory study in the United States, which have since been discredited for their flawed methodology by the society, by the Association of child psychologists and social scientists, by that consensus. Now, those studies have a huge, undue amount of influence over policy. In Australia, at one point, barristers said that if they couldn't get overnights with for fathers, they'd been Macintoshed. So and it was a similar situation with the Emory study in the US. Those studies have been roundly taken apart for their flawed methodology.
But people don't know that, obviously.
Sorry?
People don't know that, presumably, or do they know it and still carry on with this flawed thinking?
I think there's no excuse now. Since 2014, 2015, this is about 6-7 years ago, the scientific community came up with a consensus. And I want to be very clear about this. This is not one lone study, is like Emory and McIntosh, which tried to suggest it wasn't a good idea to have shared parenting. This is a consensus of 60 studies, 60 studies in the last 4 decades that looked at the outcomes for children for shared care. And they found almost unanimously that when you look at the criteria, children did better socially, academically, psychologically, emotionally, almost virtually every single criteria when the care post-separational divorce was split on an even or a roughly even basis. The way they did it was 35% and upwards of overnights with one parent. There's really no excuse now. The only thing I can think of is that these social scientists and child psychologists aren't publicists, and that this hasn't got out there. And this is why the campaign is trying to get that science in the faces of the policymakers in Westminster.
Well, there are some other lobbyists about who may have a very different view. In other words, that actually men, the imbalance is women should have care of the child or the children, and men are redundant. You can do without men. There are some people who seem to believe that, and they're part of large organisations who seem to be able to lobby effectively. And would clearly be opposed to the idea of any natural or just kind of an assumption of shared parenting as being the natural starting point. And
I think the organisations you're referring to are possibly Women's Aid, and this is something.
There's Women's Aid is at the front there, yeah.
Is at the front there, and this is something that we want to, as a campaign, want to reach out to Women's Aid. We are not saying that if any child or any partner is at risk, that we just go ahead with a shared parenting arrangement without any questions at all. All the legislation in every single country, whether it's Kentucky, whether it's the state of Kentucky in the States, obviously not the country, Netherlands, Belgium, Sweden, all the legislation has this very strong caveat that if there's any danger to the child or to the other parent, then that rebuttable presumption, and this is the word rebuttable, can be rebutted.
Yeah.
Okay.
Yeah.
So I mean that's extremely important. What was very interesting in Kentucky, and the Kentucky legislation passed unanimously in the Senate and by about 82 votes to 1, roughly. I think those were the figures in the House in Kentucky in 2019. The National Parents Organization, which is kind of the equivalent of Families Need Fathers. Or Fathers for Justice out in the States, sat down with women's groups to draft the legislation. When women's groups are opposed, when Women's Aid are opposed to shared parenting, it's always through the prism of domestic abuse. And what we want to do is we want to say, well, look, we are not a men's rights organisation. We're not fathers' rights. We are about children's rights. We want to sit down with Women's Aid. I'm convinced that legislation can be drafted that means that loving parents, if they're loving parents and they're not abusive parents, can share the time equally, but can have the caveat that if there is any issue of abuse, then that shared parenting arrangement can be rebutted. Again, the clues in the rebuttable presumption.
So how's it going with reaching out to Women's Aid? How's that going?
I have sent several emails to Women's Aid, and they have not been replied to. It's very clear on my website that I want to reach out, and this is something that I will do because I think that is possibly, as you've identified, one of the biggest obstacles. Now, again, let's looking at this. Is this a men's issue? Is this a men's rights issue? Absolutely not. I think with Fathers for Justice, we have this idea of men dressing up as Batman and climbing up various buildings, etc. And it's very much associated as about fathers' rights as about men's rights.
It needs to be gender neutral, doesn't it?
It's gender neutral, and that is very clear on my website. It's very clear on the campaign. Let's look at the statistics. 75% of women, according to a YouGov poll and a Comrades poll as well, which had a similar figure in 2019, said that 75% of women are in favour of an equal split, or at least a roughly equal split of time for children with both parents after separation and divorce. The Women's Equality Party, arguably the leading feminist organisation in the country, or what's becoming the leading feminist organisation in the country, have in their manifesto that they are favourable to shared parenting arrangements post-separation and divorce. If you look at my website, apart from myself, every single supporter is female, including Erin Pizzey, who interestingly is the founder of Women's Aid. There are legions of organisations, especially in the States, Moms for Shared Parenting, Leading Women for Shared Parenting, one of which is on the website, that actually give a very much a feminist argument for having this change in the law. If men are taking the equal responsibility and equal time post-separation and divorce, women can progress more in their career. They have more time to find a new partner. There's plenty of arguments out there to say that actually this is as beneficial for women as it is for men. But it's not really about women and men. It's about children and what's best for the children. And again, the science is unequivocal.
We were talking to Terry White, and there's we've had a couple of conversations with Terry White. And he makes a point about Mr. Justice Cobb, who joined a bunch of several representatives of Women's Aid on the Ministry of Justice's assembled panel that then created the Harm Report in June 2020. And Terry's take on Mr. Justice Cobb is that he has form as actually undermining the rights of parents to have a role in the children's lives, that the judiciary begin to reserve for themselves decisions about whether parents even have a right or not. And clearly some parents exclude themselves by their behaviour or their difficulties. But Terry's pointing out how the judiciary or the leading figure in the judiciary seems to have a bit of an axe to grind about this, which is hostile to what you're pushing for.
Yeah, well, let's talk about another leading figure in the judiciary, the President of the Family Division, Sir Andrew McFarlane. In 2019, he, along with Teresa Williams, one of the directors of CAFCAS, in a report corrected this urban myth that 10% of cases go to court. And that was always the figure that was bandied about for many years, that 10% of separating parents, divorcing parents, go to court for child contact arrangements. In April 2019, that figure was amended. That figure is actually now stated as nearly 4 times higher, 38%.
38% of which families are we talking about? Separated families?
38% of separating families.
Yeah, right.
Go to court over child arrangement orders.
That is amazing,
they
isn't it?
take it to court, 38%. Now, obviously, this is in the UK, which obviously does not have a rebuttable presumption of shared care. Otherwise, I wouldn't be talking to you today, because that's what I'm campaigning for. If you compare that figure, though, to Sweden, let's go back to Sweden. 1998, case law came in 1998. For a whole generation, nearly, it's been accepted in Sweden, both in case law and actually in statute as well, that when 2 parents separate, the law now will assume that the care should be divided as equally as possible, unless obviously there's any untoward issues, alcoholism, abuse, etc. For a generation.
Sure.
Now look at the figures in according to a 2017 report in Sweden called See the Child. A comparable figure to that 38% of cases in the UK going to court in Sweden is 9%. 9%. So over 4 times less. Over 4 times less. So let's put it this way. In a country which has an accepted position of a rebuttable presumption of shared care post-separation, shared time, both separation, like Sweden, the amount of cases going to court is 9%, 4 times less than a country like the UK, which does not have a rebuttable presumption of shared care.
Yeah.
Now, what's interesting, when the science says we should do one thing, the science is unequivocally saying that it's in the best interest of the child, in most cases, unless there's any issues, etc., as we've discussed, to divide that care up. That's what the science is saying. Why isn't the law saying that?
So where do you think Sir Andrew McFarlane comes in, though? Because you mentioned him, but where do you think he comes into this discussion about the law? We've got Cobb seeming to be pushing to weaken the parents' rights to shared care. But where do you think McFarlane sits? Do you have any impression of that?
I don't have, and I've tried to contact his office several times. I don't have any impression or hunch whether he is favourable or not favourable. What I'm saying and what concerns me is that the legal profession, if you're a family lawyer, whether you're Cobb McFarlane or whether you just want a rank and file family lawyer, and you look at the figures and you look at, well, if we have a rebuttable presumption of shared care, and if the numbers of cases going to court in the UK is now at 38%, if we bring in a similar law to what they have in Sweden, that number could go down to 9%. Therefore, that would be over 4 times less business, as it were, for the family court, for family lawyers. Now, obviously, that would create a little bit of a concern if I was a family lawyer. If I was a plumber and they were going to bring in a law which made it 4 times less likely that people would need plumbers, plumbers would be concerned. So there is an argument to say there could be a vested interest. Now, when we have people like Cobb coming up with arguments about children need a stable home, all these arguments that sound very child-centred, that they have the best interest of the child at heart, but fly in the face completely of the scientific consensus, you do have to ask yourself if there's any vested interests here. And again, look at this.
I was a lawyer, you probably know that, but I would hope that you would decide that there's plenty of other things that you can do in the law. You know, you can move to another subject, you can go to work in crime, you can, do something different. So I'm hoping that the lawyers aren't thinking that this is a great money spinner. But then, what do I know?
Well, all I'm saying is that when you have science, which says one thing,
I accept that.
But the law is not following it. Let's take an example of cigarettes. We've known, I'm 44, we've known since I was a child, even before I was a child, that cigarettes are dangerous. They're still not banned. We know it kills people. The science is absolutely, we all accept the science says that. No one questions that cigarettes aren't dangerous, don't kill you or make you seriously ill. We still sell cigarettes. Why is that?
Yeah.
Well, the answer is possibly a vested interest in that, it brings a lot of tax revenue to the Treasury. I mean, that's the answer. And I think people accept that. People raise eyebrows when people suggest, quite rightly in most cases, when people suggest some sort of conspiracy. But I mean, I'm trying to find an answer here. I mean,
I think I'd speak from my profession as a doctor. I think it's more a problem, at least I'm guessing. I mean, no, I haven't had a drains up conversation with family lawyers, but my guess would be that it's more that if your only tool's a hammer, all problems look like nails. And And this certainly afflicts doctors. That is, that if your solution is medication, all problems look as though they need to be medicated. And I think that probably the same comes to lawyers. If what you offer is legal solutions, then every problem looks like it needs a legal solution. So it may not be a conspiracy so much as just ignorance and a failure to look at the bigger picture, because people are busy, they've been trained, they got their weekly experience of how marvellously they manage to intervene in people's lives, and so they see that as being the best thing to do. And it may be as simple as that, and not actually a financial incentive, although that may be in the background, of course. What would I do if I lost 3/4 of my cases? Of course,
bound to happen.
It could be there, but it may be simpler, that it's just ignorance. It may be more a matter of raising consciousness. And
another interesting thing, though, I was just thinking about is you don't really even need the science, though, do you? Because isn't it well known that couples who bring up children, the children have much better outcomes than, say, single parent, single parents who are struggling.
It's worse for children. I think it's well established.
It's worse for children, yes, and that you don't have to be a scientist. You don't have to look at research for that to be recognised, I don't think. So why you would then argue? I mean, I'm wondering. I would like to ask you this: if people can separate amicably, I can see that this would work really well. What about these cases, though, when there isn't necessarily domestic abuse or really serious issues, other than people like, I don't mean fighting as in physical fighting, but they kind of like the relationship where there is some conflict. Do you know what I mean?
Did actually, the science, these reports I referred to earlier, the 60 reports over the last 4 decades, the consensus of scientists, they included cases where there was antagonism in relationships. And that's extremely important, because obviously where there's cases going to court, there is that antagonism there in relationships. Now, what the science said is that even if there is antagonism between the parents, and then there's conflict, I mean, not physical conflict as you say, but some sort of conflict between the parents, even in those cases, the science unanimously said that the children still do better when there is that equal division of time post-separation or divorce. And I think we need to change. Yeah, and
but I don't think people would know that. Sorry to interrupt you. I don't think people would realise that.
That's why I'm here.
Yeah.
That's why I exist. This is the whole point. This is to try and get people to understand that the key tenet of, quite rightly, of the Children and Families Act 2014 and a similar family Children's Act all around the Western world is the golden thread is the best interest of the child. Now, if science is stating, a consensus of scientists are stating that it is in the best interest of the child to have a rebuttable presumption of shared care in legislation, because that is the case, there's no counter consensus saying the opposite, then surely that's what we need to do. Society, the law has a responsibility, and politicians have a responsibility to change the society through legislation. Often it does work that way around. In Sweden in 1998, only 2% of couples shared care after separation or divorce. When the law came in the late 90s in Sweden, that number now today is over 50% in Sweden. I'd like to talk about vested interest a little bit more in money, and it may be cynical of me to suggest that this fourfold decrease that could happen in a generation to family law, cases going to family law would trouble family lawyers. But let me indulge in a bit more cynicism. There was a report by Brian Hudson recently, who you may know, you may have interviewed him.
Yeah, we know him.
And now, I'm not going to be drawn on figures here. I was talking to him this morning, and I'm not going to give figures because simply those figures are being finalised. But it is true, and I had a discussion with him this morning in preparation for this interview, that the child maintenance service gives a significant amount of money, provides a significant amount of money to the Treasury. Now, I can't be drawing the amount. It's tune of billions, but it's a significant amount of money to the Treasury.
Yeah.
Now, the Child Maintenance Service, obviously, as people know, chases parents who to pay maintenance for children. Now, if we have a situation where we have an acceptance both in law and in society that when couples separate, the share is more or less equally divided, then some of that money that goes to the Treasury will be eroded. Not all of it, but some of that money will be eroded. And there possibly is a reason why the politicians are a little bit slow to accept that the science needs to change. That the law needs to change to reflect the science.
But the other more obvious financial incentive, which I think is kind of it's widely disputed, but anyway, the benefit of claiming to be a victim of domestic abuse and thereby triggering legal aid funding is another issue which would need to be addressed if you're going to reduce the number of cases that are being disputed in the family court, because at the moment there seem to be quite a lot of indications, given the actual drop in the number of domestic abuse incidents occurring, the rise in the number of allegations of domestic abuse look like evidence for allegations being false in many cases. I mean, very hard to establish, much disputed, but plenty of anecdotal evidence that people are using allegations of domestic abuse in order to secure legal aid funding. And of course, if you have that going on, you're still going to have a whole lot of cases being disputed, because if parents want to fight, that's a good way of fighting, and you escape from this rebuttable assumption.
Yeah, and even if I'm successful in campaign and we do get a rebuttable presumption of shared care in law, it will obviously inevitably have to have the caveat of domestic abuse. If there's any domestic abuse, that rebuttable presumption is rebutted. Now, so obviously a change in the law a change in any law never solves all the ills in society.
Sure.
I mean, we've had lots of changes in the law to promote equality, racial equality, gender equality, but no one pretends that things there are perfect today. But you're right. I mean, it would be a huge step, but it would just be a step in the right direction. It wouldn't be the end of the journey. Now, domestic abuse is something which is used by some unscrupulous family lawyers would say, look, if you allege domestic abuse, there's no way that one of the parents is going to get some time with the child, or let alone an equal split of time with the child. So if you allege domestic abuse, that's your silver bullet. Now, how do we deal with that? Well, I think family lawyers need to be held for account if they actually suggest to their clients that they somehow construe some argument of domestic abuse which is spurious, that they are sanctioned by the Law Society very strongly. And let's have a look at women here. I'm a father of a daughter. I feel very angry about parents, and it is often the female parent, often the mother, who will make a false allegation of domestic abuse. I feel very angry, not only because does that scupper a child spending time with a loving father, but also, and this is something which Women's Aid need to recognise, your enemy's enemy is my friend, your enemy's enemy is your friend, that mothers who make false allegations of domestic abuse are actually causing problems for women who are genuine victims of domestic abuse, because they're less likely to be believed. And this is something where there is common ground between my campaign and Women's Aid.
Yeah.
Well, I'm constantly thinking of the Trill adverts when we talk about Women's Aid, because I'm going to get boring about this, but I mean, this is remember, Trill had 80% of the market, and like Women's Aid does, and they wanted to increase their market share. Very difficult thing to do. So the clever solution by Murray Walker was the slogan, a single budgie is a lonely budgie. And in fact, what you then do, of course, is increase your market share because you double the number of budgies. not the market share, but increase the market. And Women's Aid have got a clear incentive for increasing their market by incorporating some support for men, but also a single parent is a lonely parent. So, you can apply the slogan, both ways as a motivator to open up this market, so that there's a recognition that children do need two parents, and that providing services for men who are also on the receiving end of abuse or some other kind of mistreatment are equally entitled as women to have the support that's needed to help them through it.
Because men often lose accommodation.
Well, men are in a vulnerable position because they're very often not the resident, not the parent with residence. So
I think we talked about entitlement. I think there's another issue here. One thing that gets thrown at me sometimes is that, or thrown at fathers groups, which look at it more from a father's perspective rather than the child's perspective, and can be guilty of that in some cases. This is about parental entitlement. This is about sort of mainly dads, a non-resident parent, which is mostly, but not always, but mostly the father, saying this is about my right to see my child, to have an equal time with the child. What we don't talk about is the de facto parental entitlement of the non-resident parent, and without a rebuttable presumption of shared care, left to its own devices, society accepts this sort of argument, this idea that I'm the mother, I'm somehow entitled to be the resident parent. I've got this entitlement, this de facto entitlement. And the law as it stands, although it doesn't specifically permit that to be said, if you read between the lines and you look at how weak the law is written on encouraging shared care post-separation as it stands, it does encourage some resident parents, some, not all, mainly, but not only, mothers, to say, look, I am the mother. I am entitled to have the child with me most of the time. If you don't like it, take me to court. Because the law as it stands, de facto, as it were, does encourage that. And that is extremely damaging to the child. Extremely damaging to
I think that's the point that we have to keep returning to.
Extremely damaging to the child. And that is why the law needs to change, because the law as it stands does encourage some sort of de facto parental entitlement. It's the entitlement of the resident parent, normally but not always the mother, to say, look, this is my child, they're staying with me, you don't like it, you take me to court. This is why we need a change in the law.
Yeah, it's entirely right. And of course, there will always be people with bad motives trying to distort the situation to suit themselves. And the touchstone has to be the welfare of the child. What is actually in the interests of the child, not who's got this right or that entitlement. That really shouldn't come into it.
Do
we know where Kafka stands in this situation?
Yes, we do. What's very interesting? What's very interesting? I've been talking to Kafkas, and what's very interesting is I've mentioned before how the law in the UK is way behind Sweden, several states in the US. Netherlands, Belgium, etc. But interesting, the statute in the UK ridiculously lags behind the UK case law and also the approach of Kafkas, which is the body which is supposed to advise the court. Kafkas actually says in point 9 of its good practice guidance that where there is no safeguarding issues, the involvement of both parents should be maximised as much as possible. That's what they say in their good practice guidance notes. Point 9, in fact, is on their website. Now, yes, it doesn't say time, but it's difficult to see. It's very nuanced, but it's difficult to see how you can be equally involved with a child if you don't have near enough equal time with that child. Now, that is what Kafkas are stating. That is what they are telling their officers to bear in mind when they do their Section 7 reports. But that is actually significantly more favourable to shared parenting. And the actual statute law, as it stands, which says that children benefit from it should be presumed that involvement of both parents is to the child's best interest, and then it goes on to say that involvement can just be direct or indirect, but no division of the child's time, which is very, very watered down, very weak.
So that's one door which seems kind of open. So that's very encouraging, isn't it? That at least that shouldn't have resistance from it.
Statute law was a case in 2006. Where the CIV 235, that's the legal reference for it, Court of Appeal England and Wales, there was a ratio desciendi, which I think is what the lawyers call it, by Lord Justice Thorpe. It was paragraph 21 of the judgment. I did warn you that I was a bit of a shared parenting geek. Now, that actually lays out in case law the parameters by which there should be a shared parenting arrangement which is encouraged. Now, again, so we've got case law, which is saying we should have, shared parent, pushing towards shared parenting, or certainly more than we have now in statute. CAFCAS, which is the family court's own advisory body, saying we should go further, but statute is stubbornly lagging behind. So our statute in the UK doesn't only lag behind the rest of the Western world, it also lags behind its own advisory body, and it also lags behind the case law as well.
Presumably, CAFCAS don't keep records of what they recommend in their reports, because it would be interesting to see how many recommendations are made for shared parenting, or maximising both parents, parenting. Because I don't pick up this idea that we have a lot of CAFCAS officers saying this to parents.
But then we're not hearing from people who've had a good experience.
No, quite. But we hear it's still this kind of mum has the majority of the care, and dad gets weekends and maybe some evenings.
One thing that is quite disturbing. I had meetings with CAFCAS. I had meetings with Sarah Parsons, the head social worker. What was concerning in that meeting? I mean, no disrespect to Sarah Parsons or anyone else at CAFCAS, but they were going back to the studies. They were citing studies like Macintosh and
right.
And they were still sort of using those, and they hadn't really accepted. And I had the conversation at the CAFCAS conference in 2019 with the director of operations, whose name has temporarily escaped me.
Anthony Douglas.
Anthony Douglas.
Not Anthony Douglas. He was the then chair. But she was saying to me that she just didn't accept this consensus. I think there is a little bit of denial in CAFCAS, which is a problem. About the consensus, the scientific consensus. They're not really taking it on board or seeing it as significant. They're still clinging on to these lone studies like Macintosh, which have been completely discredited. These studies which state that children are better off maybe not having overnights with dad until they're a certain age, or whatever it might be. They're still clinging on to these outlying studies, which have been their methodologies been completely taken apart by the scientific community. They're not accepting this consensus, and that is one concern with CAFCAS, and that is one gripe that I have with the organisation, and that's why I'd like to sit down. If they can produce to me, if Jackie Tiotta, the CEO of CAFCAS, can sit down with me and provide 60 studies in the last 40 years. Which say that children are better off living mainly with one parent and having the other parent sort of hopping in and out here and there, I'll shut up. I promise that. You've got it on record. But until someone like Jackie Tiotta or Sir Andrew McFarlane can produce those studies to say the opposite, a consensus of studies which say children are better off with one parent and the other parent hopping in and out, until then, I'll keep talking.
I think we're talking about inertia rather than an ability to actually oppose you. It's more like a resistance to shift, isn't it?
Maybe.
And,
another objection which comes up is that we looked at this in 2014. We had the Norgrove report, and in 2014, I think it was Ed Balls commissioned, the then Children and Families Minister, commissioned the the Norgrove report in Australia, and Australia had I've been assiduously avoiding the example of Australia for that very reason, but Australia is another example of a country which has legislation more favourable to shared care. Now, Norgrove basically stated in his report that one of the things he stated in section 4 of his report that cases, if you have shared care enshrined in legislation, it's more likely to lead to court cases and acrimony and fighting in court, which obviously is not in the best interest of the child. And this is why Norgrove recommended that we didn't go that far in the 2014 legislation. So it was kind of knocked on the head by him, and it was knocked on the head by Baroness Butler-Schloss, who inserted that amendment in the third reading of the bill in the House of Lords, to basically water it down and make any involvement meaningless. No division of a child, no particular division of a child's time, and direct or indirect contact. Absolutely ridiculous. But what's interesting is that Professor Patrick Parkinson, in his 2012 report to the pre-legislative scrutiny committee that were examining the bill. He gave written submission to the committee examining the bill when it was going through the stages in the House of Commons. He said that, and this is Professor Patrick Parkinson, the professor of law at Sydney Law School. So you'd think he'd know a thing or two about Australian law, wouldn't you? A little bit more than Norgrove. Who wasn't. So he actually said that Norgrove was wrong in virtually every single thing he said. But still, the Norgrove report influenced the final bill, and we have what we have. And one of the things that he said that Norgrove was badly wrong on, and probably the most significant thing, is that rebuttable presumption of shared care, or in the Australian example, a move towards shared care. It didn't state it so clearly as that. A move towards having shared care enshrined in legislation causes more cases to go to court. That was one thing that Norgrove got wrong, probably the most significant thing. And that is, now you talk to politicians, they, very often in 2014, Norgrove said it was a bad idea, so let's can it. And that objection is something which, can easily be overcome.
So it's down to educating people again, isn't it? Giving them updates on what they need to know and what science.
Since Norgrove,
but evidence is the key to this.
Since Norgrove, three things basically have happened. We've had Norgrove been shown that he was wrong by Professor Patrick Parkinson. The cases do not increase in other countries, and when we've had legislation subsequent to the Australian legislation in Kentucky, the cases went down in the family courts. We've had this admission that the cases going to courts in the UK are not 10%. They are 38%. They're extremely high compared with countries that have a rebuttable presumption of shared care, with all the costs that cause. And most significantly, since Norgrove, we've had the scientific consensus that says, guess what? Science says we need, that it is in the best interest of the child to have a division of time, an equal division of time post-separation or divorce. Let's change it.
Well, we're all for decisions to be based on evidence, and as you say, the evidence is there, but people choose not to pay attention to it,
or haven't been told about it.
Or haven't been told about it.
If people want to believe that science says that children are better off in one home and the other parent visits them here and there, what can we do about that? If people want to believe the earth is flat, what can we do about that?
Well, we try not to make policy on that basis.
We try not to make policy on that basis.
Although there's plenty of religious policies around which you might question on that basis as well. But still, let's not get into that.
Let's not get into religion.
But we are against traditional attitudes. I mean, you're talking against traditional attitudes, and I guess that's where the sticking point is. Really,
I think that is the problem. It goes back to I had a meeting with an MP who was writing a manifesto, Fiona Bruce, not the presenter, the MP, who was writing a manifesto on. This is several years ago now. She was writing a manifesto for the Conservative Party on families and children, and she said to me, "Well, look, that if the society the law needs. Can the law really change society? Can the law actually change attitudes? And that was before I went into that meeting. I was speaking to Michael Liskowitz of Families Need Fathers, and he gave me the statistic just before I went into Portcullis House, and it was very useful. I said, actually, Fiona, or Ms. Bruce, I can't remember how I addressed her now, but actually, the law does change. The law can change attitudes in society. If we have in Sweden 2% of couples were sharing care before the change in the law. Now today it's over 50%. So that is an example of the law saying, look, in modern society, this is what's expected. This is what we expect people to do. 2014, we had gay marriage. The law says society needs to accept that gay couples are just as equal as heterosexual couples. And I'm drawing that parallel because law does need to make that statement to society that things have changed. Both parents need to look after the children. Both parents matter equally to the child.
Well, both parents love the children, so they should want what's best for the child.
We want to support you and encourage you, Will, and I think that's a great polemic, I might say, at the end. We're all for it. But I think our faith has to be in evidence, decisions based on evidence rather than on prejudice and simply traditional bias.
You're getting the evidence together to produce to people.
So
exactly that, and hopefully it will get in front of the legislators, the people, the decision makers, and all we can do is keep pushing. Keep showing.
Thank you very much, Will, for giving us your time
interesting.
and telling us what's going on. That's really helpful.
Thank you.